welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm joined today by Clayton Calvin. And today we are not bringing you Supreme Court precedent or jurisprudence or any of that because we have a Supreme Court justice here with us. This is Justice Sullivan of the Texas Supreme Court, and we are so delighted to have you here today, sir.
Well, I'm grateful to TPPF and to y'all for taking the time to have a fun conversation about the work of our branch and whatever else you think your viewers and listeners might like to hear.
And we're going to be a little cautious for listeners who don't typically hear judges be interviewed, because frankly, it doesn't happen very often. We appreciate you taking the time to do this. We're not going to ask you about cases. We're not going to ask you about things that might show up in front of you, because we want to respect your ability to stay independent in those things.
I appreciate it.
So we are going to talk more about you and who you are as a person, who you are as a justice. And like you said, we're going to talk about the court. We're going to talk about Scotex.
Okay.
And first and foremost, are you aware that you share a moniker with a certain blue and purple monster from a certain children's movie?
I am aware of that. I remember when the first one of those came out when I was in college, and my uncle had a printout and said, "Hey, there's going to be a James P. Sullivan character in this Pixar movie." And I said, Uncle Tim, you got way too much to do to be like, making up, joke press releases like this. But I've always been Sully. I guess now I'm Judge Sully. And I haven't always been this furry, but now, as your listeners will, hear my annoying voice, I wish I had John Goodman's voice since he did Sully. But yes, I like to tell people I didn't land a plane in the Hudson.
I was going to say.
Yep, that is the other major Sully.
And I'm not the Monsters, Inc. character. But as ballot names go, hopefully it'll be good for younger voters this year. So.
At least every person who was a child when it came out and who is now a toddler parent will vote for you by default.
Just win, baby.
Just whatever it takes. You mentioned just now that you call yourself Judge Sully. You're a justice, right? Mm-hmm. What's the difference between a judge and a justice?
It's a good question. There are a lot of those little semantic things. Sometimes we'll be introduced, by friends from out of state as associate justice. That's actually not, associate justice is technically not the title under the Texas Constitution of 1876. So the title is justice. But everybody at the courthouse, they'll say, good morning, Judge, and that sort of thing. And it's easier to say Judge Sully than it is to say Justice Sullivan. So any of those are fine, or just Sully. I've been called a lot worse. So
just generally less pretentious sounding to say Judge Sully. So let me ask you this. I did a little bit of research on you leading up to this, and you've come on record before saying you became an attorney because of a football injury.
Yeah.
What is that story?
So I grew up here in Austin. The two Austin claims to fame. I was an extra in the movie Dazed and Confused, because my dad and I built the 1970 Orbit Orange Pontiac GTO Judge that was the hero car in that movie. And I played football at Westlake, so I hit Drew Brees in practice once as a scout teamer. Oh. And when I got to Rice, I started as a physics major there and walked onto the football team. And after a year of doing that, I realized I was not going pro in football or in physics, and so and I hurt my back lifting weights, and so I left the football team, stopped doing physics, and was looking for some other competitive outlet. And so I joined Rice's debate team, NPDA, National Parliamentary Debate Association, and used the 40 plus hours a week that had been being a tackling dummy for the Rice the Peckin' Owls football team, and devoted that to a different competitive outlet. And doing debate really solidified for me the desire to go and crush your enemies, see them driven before you, hear the lamentations of their women, but to do it in kind of a nerdy way from the debate podium, and that was a pretty natural transition to then take me to law school, where I met my wife.
Yeah.
Wonderful. Yeah, that's great. Could we ask you a little bit about you're here as an amazing representative of the judicial branch. Can you tell us a little bit about your process in there? Like a brief hits your desk, like what do you do?
So I am not a bleeding edge technologist. I like hard copy stuff. Some of the stuff we'll read online. We get over 1,000 petitions for review a year. So, it's not like I'm felling forests printing all of those, but the things that I'm going to be reading more carefully, I like that if I print it out and make notes on it, it's never going to disappear into the cloud.
Gotcha.
There's never going to be a software update where I lose things.
Right.
And that's just how I've kind of always read best is, drawing little mustaches on things and making notes in the margins. And so it kind of depends on which phase the case is at. When we're at the petition for review stage, where we're trying to decide with our discretionary docket which cases we're going to take, there's a lot more volume to get through there.
I can imagine.
And but once something kind of gets, once I've kind of pulled something off of the conveyor belt and identified it as something that I think that there's an issue that is important to the jurisprudence of the state, then I'm probably going to have a notebook put together that has the briefs, the text of the statute, and for me, I usually won't just take subsection A of section 23.211. I'm just making one up. I'll often print off the entire chapter that the disputed provision appears as a part of, because you need to read text in its context. Have the briefs, some of the key cases. My law clerks are outstanding at helping put these things together, and then as the case kind of moves through the process, then I have kind of a running tally of the things that I've thought are maybe important, and I can put tasks in the margins and ask clerks saying, hey, could you go pull this opinion for me, and maybe take a first pass through it.
So you've got little the classic law school what do they call it? The tabs.
The
with different
tabs,
colors
yeah.
and you write the
little
notes
tape
there on the
flags
side. Okay.
and different colors of pens and stuff like that.
Cool.
And when a case is assigned to me for writing, or if I'm going to write a separate opinion, then sometimes I'll talk with my law clerks, and sometimes I'll ask one of them to take a pass at a first draft. Sometimes I'll take the pen myself.
Okay.
But the goal through that iterative process of going through drafts and sending edits around, it's my name on the commission.
Right,
It's my judgment that's reflected in whatever it is that's going to come out under my signature. So getting it, through the process to being in my voice, which I guess is somewhat distinctive.
Right, totally.
It absolutely is.
Very much.
But I love reading good writing, and I love writing, and so the job it's just fantastic.
Amazing.
It's a lot of fun.
I would imagine that sort of I don't know if you'd say old school, but the sort of manual method that you're describing, and where you just have your OG, the brief and all the stuff that you've compiled, helps you keep your distinctive voice while it goes around, because it's not flying everywhere. You just have your original copy and binder and everything. On your distinctive voice, you are well known for putting great pop culture references and zingers, and I mean, we have how many times have we
I think we have
laughed
a running
out loud?
list. Yeah,
Like,
of the
we've been
things
reading.
Judge Sullivan has said.
Yeah, no, it's like they're so fun to read, but they're so crisp and witty, and the legal issues are certainly don't suffer for all that pop culture reference. Can you describe? Is there a philosophy behind that, or does it just flow naturally? Do you start with the cowbell and you move outward? How does that work?
For me, one of my judicial heroes is Antonin Scalia. And one of the things that I always admired about Justice Scalia's opinions, these things don't have to be boring. And the way that he would use his gifted pen to make things stick, this wolf comes as a wolf,
Yep.
make things a little bit more memorable, but also make things a little bit, more readable. The judge I clerked for, Judge Thomas B. Griffith on the D.C. Circuit, his kind of philosophy that we had tried to help him reach, his goal was that a well-educated high school senior ought to be able to read the opinion and at least know what's going on. And so for me, I want it to be clear. I want people to understand what their court is doing and why, and what the principles are in future cases for bench and bar alike. And then I try to write it the way that I think it, and so I don't go out of my way to find a reference for this or that thing.
Yeah,
but
they're just all there.
Yeah, and sometimes if you couldn't, but if you went back and looked at at my copy of the brief, I may have written in the margin somewhere, hey, the card says moops or something like that.
Yep.
And if that's the way that I think of it, then that's the way I'll do it. There are certainly some cases where it's a little bit of levity is not appropriate to put in there. So I had a case during my first term that unfortunately was about a young child who had been run over by a school bus. So that was not the time to yuck it up or anything like that.
Not a good time for a Big Lebowski reference.
Right, exactly. Yeah. But yeah, I try to, instead of putting in a bunch of $20 words that you then have to, when a lower court judge or an attorney reads it and they condense it down to like, well, this is what the rule really is. If I can, the way that it came out of my head, it can go right into somebody else's. I think that generally it's just better to be clear
and succinct
and readable.
Yeah, absolutely. So kind of on that same note, or at least in this kind of process area of questions, what do you see as the value of oral argument? Is that something that frequently changes your mind as you're going through your briefs and through that process?
Frequently, no, but it happens sometimes. Okay. I had heard before becoming a judge, some judges would say it never changes their mind. For me, I've had more than one where it did, and I think that is, and my colleagues are fantastic, and I think that the best questions, from some of my colleagues are the ones where I end up writing something down and saying, we need to go take a look at that. I hadn't thought of that, but if the counselor does not have a very good answer for that can often be really, really telling. And for me, I always urge advocates, in CLEs and things like that, to think of oral argument as a very rare and small slice of time where you get to sit in conversation with the multi-member group that is going to be sitting in judgment of your client. And so understanding which parts of your case you might prefer to win on, but you can push over the side, knowing which things you can concede, it can be really important. So for me, it has definitely changed my thinking on cases in the past. Part of that is because of what the advocates do, and part of it is because I've got 8 really smart colleagues who will often come at problems in a different way than I had. I when I was an appellate nerd lawyer, I loved oral argument, and now during oral argument week, instead of having one case, I've got 10,
right.
And that's just a blast. The hardest thing to get used to has been that we have cameras in our courtroom, which is great for civic education, but I've had to get used to the camera comes on me when I have a question, and then judge friends of mine texted me saying camera adds 50 pounds, but only to you. So, it's just part of it.
My mom watched Chance's oral argument in front of you guys, and heard you say, could you hum a few bars on, I think it was the opposing counsel, and she's your biggest fan now. She feels civically educated.
So do you think in general that you get more from longer or shorter oral arguments?
Boy, it really depends. There have been longer ones that I've gotten less out of, and there have been shorter ones where I went in thinking, if this particular lawyer doesn't have a good answer to this, there's just no way that they can win. And so a lot can be accomplished in a shorter time. But I think that as long as any of my colleagues, have questions, I think that it's a good use when we've got everybody together. Everybody, is speaking on the mic. And so, I think that we get the amount of time for oral argument in our cases about right. I don't think that it would be particularly productive, like in the really olden days of U.S. Supreme Court arguments, where they would have like 3 days of oral argument. That may
oh
be,
boy,
yeah.
Yeah, that makes my inner appellate advocate go,
right.
I think of the movie Amistad, where he's in front of the United States Supreme Court and arguing his case, and he's walking around the courtroom and delivering the soliloquy. It's like, that's not typically how it happens.
Yeah, we've had a couple of advocates who seemingly have a difficult time distinguishing the 9 of us with our robes on from a jury. We're there to follow the law, and this whole system is out of order, pounding on the desk.
Exactly.
And maybe isn't going to be the
you
best.
Can't handle the truth.
Yeah,
which actually might be a good time to bring up something that not all of our listeners might know. We've got listeners all over the country, and a lot in Japan. Weirdly,
we have a lot in Japan.
Hello to Japan. So Scotex is distinct and unique among Supreme Courts of the states in that you only hear civil cases, right?
I think Oklahoma has a similar division, but that's the only other state that has it. But yes, under Article 5 of the Texas Constitution, the Texas Court of Criminal Appeals hears most but not all of the appeals in criminal cases. Juvenile cases are the exception. Those still come to us.
That's interesting. I didn't know that juvenile appeals came to y'all. I mean, I guess it makes sense. It's part of the family code, so technically, those are civil proceedings.
Right, but it's in a state as big as Texas, with as many courts as we have across 254 counties, we're certainly grateful that the CCA, the Court of Criminal Appeals, has an important and difficult part of the docket that they handle.
And that kind of leads to a question that, and I know that the answer to this is complicated, so if it's too complicated for the answer here, set me aside and we'll talk about it after the fact. But when a question of constitutionality, which is typically something that would land in front of you all, arises with respect to a criminal statute, is that something that you all can opine on, or does that have to be done by the Court of Criminal Appeals?
So currently, to my knowledge, there is not any jurisdictional basis for the Texas Supreme Court to opine on a question of constitutional law. The CCA judges and the justices of the courts of appeals and district court judges, we've all taken the same oath, and we all have an obligation. The Constitution is our highest law as a matter of state law, and so the judges on the CCA will opine on that too. If I remember correctly, there was a bill. I can't remember if what stage it got to during the 89th legislature. I think there was a bill in the 88th legislature as well, having to do with with the Texas Supreme Court being able to opine on some of those questions of constitutional law, because it does come up from time to time. There's one example I can think of in particular where our court had said something on an issue of constitutional law in the 1800s, and the CCA went in a different direction. And I don't think that you need a decoder ring to know that Supreme means Supreme Court.
Right.
But
right.
It is a really interesting point that you raise, and I know that there have at least been some bills that would allow the Texas Supreme Court to opine on
Would
something.
that require constitutional amendment probably to fix that, or is that something that could be done by the legislature?
I think that if I remember correctly, the bills were not attached to a constitutional amendment. Our mandamus jurisdiction under Article 5, might have been a hook for it, but
right,
I don't remember.
That would make sense.
I don't remember all of the ins and outs of it.
Interesting.
Yeah,
Okay, well, let's move on a little bit to just philosophical stuff. We have had many a heated discussion, both at this table and upstairs in our offices, about the real definition of originalism. So what is your definition of originalism, and how is it different, if at all, from the way that you would define originalism in the federal system versus the state system?
Well, I think that the enterprise is probably the same in the state and federal courts. To me, the propriety of originalism stems from, there's a reason that we write these things down, constitutions, statutes, and things like that. A free people will, govern themselves and bind themselves based on not, rule of law, not rule of man. And so writing these things down is done for a reason, and the enterprise of originalism is saying that essentially the original public meaning of some ratified constitutional text or properly enacted statute has whatever the original public meaning of that text was at the time that it was ratified or enacted, because that's the thing that that the people's elected representatives and senators and then the governor actually wrote into law. And so it doesn't have anything to do with hidden intent. If the notion that a collective body could have one intent anyway, Judge Easterbrook has kind of explained why that's a little bit silly. But it's not about intent. It's not about vibes. It's not about the purpose of the statute. We wrote something down for a reason, and then by our best lights, we have to try to understand what that text meant to the people that enacted or ratified it at the time they did it. The time that I spent as Governor Abbott's general counsel was really helpful to me in that regard, because the notion that something could be buried in some kind of committee report or floor statement or something like that. Right. Governor Abbott read every word of every bill that reached his desk through the process of presentment, but what didn't happen is go and read every floor statement. Right. And people in the governor's office were following that, but at the end of the day, the thing that reached the governor's desk and that we were assisting him with is, how do we understand these words to do something? And what it means is that's what law is, not what judges would prefer that it would be.
Right. It's not some hidden secret meaning. Right. And it's also not just whatever the judiciary wants it to be.
Exactly. And you asked whether the enterprise differs in federal courts versus state courts. I don't think that the enterprise differs, but we have a whole different set of sources because the people of Texas amend the Texas Constitution all the time.
Right.
It was made intentionally difficult to amend the U.S. Constitution, whereas the Texas Constitution, every odd-numbered year November, there are usually a dozen or more of these things that are on the ballot for the people themselves to take a look at. And so what that means is if you're engaged in originalist interpretation of the federal Constitution, you're probably looking at some pretty old school documents, whereas all of us sitting here today are all founding fathers and mothers of a lot of the text of our Constitution.
That's a good point.
And so that's also how we end up in this as we approach the 150th anniversary of the Texas Constitution of 1876. That frequent amendment is why, to my knowledge, ours is the only constitution that expressly mentions NASCAR.
Yeah.
In one
gets rid of our treasurer in Galveston.
Yeah, exactly.
Yeah.
And so that part of it is really fun and exciting. We've had some cases this term about some relatively recent amendments, and last term too, relatively recent amendments to the Bill of Rights and Article 1 of the Texas Constitution, for example. One of the things that's always been interesting to me every time I've voted on proposed constitutional amendments, I would go and find them and read them, but the voter doesn't actually get the text of it. They just get whatever the Secretary of State gets to write up
the synopsis.
The synopsis, yeah.
That's fascinating, because I was going to say one of the other reasons we militate or argue in favor of originalism is the consent, the basic consent.
Right, so because we're good Lockeans around here.
Yes, it's like what were the terms that were consented to by the people or in the social contract in a constitution. So when you say that the people who are ratifying the Texas Constitution only getting a synopsis but not the text, it kind of bears on the consent factor.
Right, and I mean these documents are publicly available to them. You can go and find the joint resolutions proposing the amendments.
Yeah.
And I confess that some of them, even if the people had access to them, some of them might be fairly confusing.
Right. Yeah.
But I've always found that pretty interesting. And so then, what you have, I'm trying to remember whether this opinion is out yet, but if you have, a constitutional amendment that was ratified within our lifetime, then you may have people going out and looking at, what did some of the coverage, say about this? What was in front of the people of Texas when they chose to ratify a particular amendment?
So for our little listeners who are in law school right now, who are trying to understand how we do originalism, what is the role of those things, like the press coverage, or if you're looking at something like in the Federal Bill of Rights, like the role of the Federalist Papers? What, if we're not looking for intent, what are we doing when we look at those things?
What we're trying to do is figure out how ordinary users of the English language would have understood the text that was put up for ratification at the time that it was done. And so things like the Federalist Papers can be very valuable as part of that enterprise. If you just had a bunch of contemporaneous dictionaries and you tried to pick out, what did Webster's or this or that dictionary say. If you're not understanding it in context, then you're going to go down the wrong path. And so understanding how folks were using language and were this is part of the problem, right? You're trying to herd cats and make a fence out of a bunch of cats because you got words. You got words
out of the cats.
Yeah, you got words to try to get other words across.
Right.
But when we look at these things in their context, we can better understand. Oh. And so you do want to look to every source that you have available about how the language community understood the words, the words that were being put in front of them for ratification at the time.
Interesting. So it's not just, each term in isolation using at the dictionaries, but what do they all mean in a sentence?
Exactly. What do they mean in a sentence? What do they mean, in the broader framework of the Constitution that was being amended. And I'm not one who thinks that legislative history is really of any particular value. Again, things like floor statements and stuff like that. Mm-hmm. But statutory history or ratification history for the Constitution, that matters a great deal.
What they chose to say and what they chose not to say.
Yeah, what they had before, how it had been understood, by the people and by the courts, under the 1836 Republic of Texas Constitution and then the 1845 Constitution and the subsequent iterations of that. What things were taken out? Were they taken out for a reason? Did they use different language when there was an off-the-rack, phrase that they might have taken? Did they use different language to affect some different outcome?
Absolutely. Mm-hmm. How do you think that approach differs from textualism? I have said before on the show, and much to Clayton's chagrin, actually, we've had many a discussion about this.
All right, let's get into
that. My opinion is, at least that the way that we ought to refer to the distinction between originalism and textualism is that originalism is exactly what you just described, more or less. And textualism is that same process, but taken an approach to a statute. That originalism is just how we refer to the constitutions, and textualism is how we refer to statutes.
And I disagree.
Yes, Clayton disagrees. I am told that is not at least how it is currently used in common parlance. What would you say
what's the counterpoint?
What is your...
Well, I would just say, originalism, maybe it is a form of text. Textualism would just be focusing on the text, and maybe outside of the context that you were describing, the importance of context. And so if the language evolves, textualism divorced from originalism might not help you get at the term that was consented to originally, and therefore that has legal legitimacy. But and then originalism would just be textualism done to properly, I guess, in context and whether it's a statute or a constitution.
I don't know that the semantic difference would turn on whether you're looking at the Constitution versus looking at a statute, because if we're looking at a statute, some of the statutory provisions that we're called upon to interpret are older than the right to hunt clause of the Texas Bill of Rights. And I think that whichever of those texts you're looking at, you should still be trying to understand what was the original public meaning of this text at the time that it was enacted or ratified. And so I think that I would probably agree that if you are doing textualism that is somehow anti-originalist, you're likely to get it wrong.
You're doing something incorrectly.
But am I making an error here? Like when people describe textualism, does anybody actually describe textualism that way or practice it that way? Probably some people do, but...
I know Scalia referred to himself as a textualist, but I don't know how he meant that to be different from what we would today call originalism.
Yeah, it seems like he didn't want there to be, hidden rights or hidden powers that weren't in the text.
Right.
Like that's kind of what he was getting at.
Yeah, I went up to my law school reunion a few months ago and was on a panel with Judge Andrew Brasher, who's on the 11th Circuit, and Judge Patrick Bumate, who's on the 9th Circuit. Mm-hmm. It was a fun and lively discussion, and Bumate referred to himself proudly as a bloodthirsty originalist.
Yes.
I think that at some point Justice Scalia, in dueling opinions, had referred to Justice Thomas as a bloodthirsty originalist.
Okay, that rings a bell.
Bumate wore that pretty proudly.
Gotcha.
So that may be where some of the semantic difference was coming in. But I think there's probably something to bloodthirsty originalism. Again, this is how a free people have chosen to govern themselves, and so we should be trying to figure out, who consented to be bound by what law enacted as a text at the time that they did it, and that part of it shouldn't change over time just because judges can look through it through
the language might evolve or something like that. Yeah, the only
honestly,
originalism is the bloodthirsty kind, is what I'm taking from this.
And honestly, if the general populace looks at something that you do or that the U.S. Supreme Court does and says, yeah, we don't want that to be the world that we live in, they can change it.
Right.
That is within the power of the people to make amendments to their own constitution and say, we don't like the meaning that you've ascribed to this, so we're going to give it the meaning we want it to have.
Yeah.
That's still a power that the people possess.
Yeah, that's right. You mentioned, the listeners who are in law school now. I think that one good sign of a rigorous and good methodological approach is that you won't always like the outcomes that you reach. If I were happy as a policy matter with every decision that I reached, then I would know that I'm doing it wrong, and that somewhere in there, I'm putting a little bit of spin on the ball and seeing what I want to see. There have certainly been times where there's an outcome that I think is really bad, and I think that that's what the legislature, or that's what the people of Texas, put into law. And as you say, we have a process for amending our Constitution, and we have a legislature that actually passes bills all the time and can change things if we say what the law is, and it's a result that the people don't like very much.
Absolutely.
Yeah. And when they do so, then you can give credence to that.
Yeah, absolutely.
You want to honor those changes as well, as by the same token.
Yeah.
That's actually one of the questions that we ask I think it's our law clerks. I know it's an interview question that we ask is, your originalism should lead you to places that you don't like. What are some of those places that you find that you have that gut response to?
I'm trying to think of an example that we had in a case. I think that a really easy example, and one of the boundaries that I think is really important for us to honor, is limits on the jurisdiction of our court or of the lower courts. And there have certainly been times where I think that the best reading of the jurisdictional provision is that this is not for us to weigh in here, but I think that it is a lot more important that when we exercise the judicial power that's been conferred on our court in Article 5 of the Constitution, that we actually have it, rather than wading into some dispute in what might actually just be an advisory opinion. And so it's something that in my chambers we try to be very, very careful about. The other one, and I'll see this a lot, is you end up with a reading of a statute that doesn't make a whole lot of sense. There may be some. I had a couple of by myself dissents this term where I thought that the best reading of a statute ended up with kind of a Rube Goldberg machine of how a particular case was supposed to come out. Yeah. And what probably happened is that the legislators who wrote up a particular statute governing this and that procedure in this and that type of case never thought of a particular circumstance, but what they wrote up calls for a pretty inefficient way of going about adjudicating something. But what I think it was President Ulysses Grant said that the best way to change a bad law is to enforce it.
Yeah.
Interesting.
And so if there is something that could be done better, then at least by my lights, we should say this is what it is, and this is why it comes out with this kind of inefficient outcome, and that's something that the legislature may want to change. But here, the judgments that our court renders, it's not because people thought that we would be particularly good policymakers. It's because they thought that we would be true to what the law is.
Yeah, and that's exactly why you're elected. So that's the purpose.
That's what people are looking for.
So let's talk about some other questions we usually ask our law clerks, if you're open to that.
Sure.
Favorite Supreme Court justice before 1950, because it's obviously easy for the after 1950 justices.
And it's not just the law clerks. We when attorneys are being hired, we have to make our fantasy SCOTUS, and so we take 9 from, you don't have to do 9, but even, contemporary or from history. So
Okay. Well, before 1950, I'll go with Robert Jackson.
Okay.
He was an outstanding writer. Despite what today would certainly be a non-traditional, academic path, he was a really clear writer and somebody who I think had a keen understanding of how governing works, in a system of separated powers. Obviously, his concurrence in Youngstown is the most famous of those. And it doesn't hurt for me that he stepped away from the court to prosecute Nazis. I thought that
right.
that
He
is
was
pretty
the
cool.
prosecutor in Nuremberg, which
Right.
is pretty amazing.
yeah, I always forget that. That is
He also
so
was
cool.
the lone dissenter in Korematsu, correct?
I believe that's right.
Something like that.
And West Virginia versus Barnett with
Yeah.
the constellation. If there's
Right.
any star in our
Yeah.
constellation.
And and that's a really good point that you raised. I think that one of the most important characteristics of a good judge is courage. To do something that might be received in popular opinion as deeply unpopular, but ultimately that is what I think the people of Texas want. It's why they've given us the powers that they've given and withheld the ones that they've withheld. We have an important but limited role. And if you have people who will play it straight and sometimes say this is what the law is, even if it's not going to be popular, you imagine some of the things that Justice Jackson did during wartime, incredibly unpopular. And he didn't. He didn't have to stand for election.
Well, and his amazing, very wise quote, I don't know if it was in an opinion or if this was something that was attributed to him, but he said, if you write your opinion, it's just that. It's not. You're not the executive branch. You're not enforcing it. You're just writing the opinion, which can be used. It's like leaving a loaded gun on the table for the you give this power to government. The government changes. You've written an opinion saying that this kind of thing, internment, whatever, is okay. Who's the next person who's going to be interned?
Yeah. I think he was statesmanlike, and sometimes statesmanlike is used to describe what I would think of as bad judging, looking out for the popular perception or esteem of your court. That I think can run the risk of doing things that aren't really law based.
Yeah, backfiring.
But for him, having come from the executive branch background whence he came,
Right.
I think that he really understood. Anything that you come up with for today's emergency and this government that you like now, how are you going to feel when it's somebody else who can do that?
Yeah.
So
Like,
that's-
right.
absolutely.
Like I've been there, I've been in the executive branch poring over these laws, looking for ways to use them in a way that I want to. Somebody else can do that too.
Yeah, and my background as Governor Abbott's
Yeah, you
general
were
counsel,
in that same role.
it was very, very helpful, assisting him as his lawyer through the legislative process, but then also, in the work of the chief executive officer and commander in chief, how our executive branch works, and the necessity of grounding those things in law, not just bureaucrats saying that they want a particular thing or we've always done it this way, so I guess we can keep doing it that way.
Do you think your experience in, another one of our branches of government, influences you on a daily basis like that, or?
Separate. I'm sure that everybody brings their past, and it maybe sometimes imperceptibly influences the way that they think about things. But I know that for me that it absolutely it does affect the way that I think about things, but not in the sense of one or the other side always wins or always loses.
Right.
But for instance. Having had plenty of conversations with executive branch agencies when I was the governor's lawyer, where we would sit down and they would say, this is the thing we want to do, and I would say, hey, sorry, stupid question here, but can you point to me in the organic statute that creates your agency? Where is it that
Where
you
do you
have
get that power?
the authority to do this thing you want to do?
Totally.
And sometimes those answers were unsatisfying,
Right.
And sometimes they had very good answers. But again, that executive agencies are creations of the state that have whatever power the legislature has given to them, and so it's an essential question to ask. But that's the sort of way that my experience coming out of, being the governor's lawyer, affects every day. Says who?
Right.
Like, sure, we can write opinions about all sorts of stuff, but the fact that we have, robes in a courthouse doesn't mean that, nobody has made us a king or anything like that.
Right, right.
Yeah,
What to be skeptical about. Makes
Okay,
sense.
so federal Constitution, the Federal Bill of Rights, we'll just start with the 10 amendments, first 10 amendments. Evens or odds? If you could only keep the even-numbered amendments or the odd-numbered amendments, which would you choose?
I think I'd have to go with the evens. Not going to toss the Second Amendment over the side. Fourth Amendment was one of the driving forces behind the Bill of Rights, and we've got to have the 10th Amendment in there. I think that one is absolutely essential to the operation of a system of dual sovereigns that we have. But it's a heartbreaking question because leaving leaving the right.
It's a trick
designed
question.
to break the heart.
Leaving the right to free exercise and things like that behind is of course troubling. I suppose that it helps to some extent that some of the protections of the free exercise of religion have been protected by statute, Third Amendment.
We don't really need that one.
It doesn't sound important until you need it, though.
That's true.
Yeah.
That's if we're ever in a situation, but hopefully having the Second Amendment still in place would prevent that.
Yeah.
That is always my answer to this question is hopefully we can just use the Second Amendment to get all of the rest of them back. That's the objective.
I like your answer though, because if the 10th Amendment, if you preserve that structural limitation, then those are the more important bulwarks for to protect
but the Ninth
liberty.
Amendment is also super, super important.
That's true. But if you're limiting everything the feds can do, then
that's true. That's true. What do you ask your clerks when you are lining them up to hire?
Well, I don't want to give away too many things because
hopefully
some of your listeners will want to try the Judge Sully clerkship experience. I try to make sure that they have an approach to the work of judging that is similar to mine. Make sure that they believe in the enterprise of originalism, and that they'll have an eye out for some of the same things that I think are important. But a lot of that is table stakes, and so I try to also ask some questions that are maybe a little non-traditional, just to see how somebody thinks, how somebody is going to deal with having to tell me that they think I'm wrong about something, because that's really important.
That's huge.
I don't want somebody that's just going to agree with everything I say. If there's something wrong in what I've said, then I want them to point it out. And then also trying to figure out whether we have similar communication styles,
right.
And some things in common. One of the big ones that I ask everybody, Judge Griffith, for whom I clerked, was essential to kind of everything that happened thereafter in my career. He was the one that connected me with the Office of the Solicitor General when Governor Abbott was Attorney General Abbott, and so part of my job for the people that come and work with me and get clerkships is to credential, train, and then fight for these folks. And so one of the things that I'm always curious to know is what would you want to use that credentialing, training, and fighting to be, what do you want to be when you grow up?
Yeah.
There's not any one right or wrong answer there, but somebody that has at least given some thought to what is the way that they're going to use the opportunity to clerk on the Texas Supreme Court to put some more good out into the world, and see what is their conception of the good and how do they see themselves fitting in there. Clerking on the Texas Supreme Court, there are a lot of things that we do that are a little different from other multi-member appellate courts. And one of the biggest recruiting tools that we have is that our clerks are allowed to sit with us in conference.
Right.
So,
which is huge.
Right. I've heard.
Right. Most multi-member courts, the U.S. Supreme Court.
That is a black box, man.
Whatever happens in the conference room. Whereas, with our conference, we have the 9 justices sitting around the table, but then we have our law clerks there too. And that is a really rare opportunity to understand how our court works, to see how the opinions get written, the decisions get reached, cases get selected, and that can be a really helpful recruiting tool.
And to hear all of the different jurisprudence, right, especially in a court that is largely, if not exclusively, Republican, to hear that those conservative jurists disagree and the ways that they disagree and how that is building the jurisprudence of the state of Texas. I can't even imagine. I'm sure
Absolutely.
that is just an absolute amazing opportunity.
One of my current clerks, Megan Corser, is going to be clerking for Judge Emil Bovey on the Third Circuit after she finishes the clerkship in my chambers. And she was, Judge Bovey got confirmed right after Megan had started clerking in my chambers. And she asked if I would write a recommendation letter to Judge Bovey, and I was happy to do it. And I said, I can say these are the good things that I've heard, but she had just started. But one of the things that was easy to say honestly was, hey, Emil, you're a new judge. I'm a relatively new judge. Because Scotex does things a little bit differently, Megan is going to come to your chambers having seen how things get done on a multi-member court, and I think that is extraordinarily valuable to any young lawyer, and I'm sure that Megan is going to be a great resource for Judge Bovey next
Absolutely. Absolutely.
Yeah, I've had good friends who've been clerks on the Texas Supreme Court, and they just are totally in awe that they get to do that.
Yeah. One last question for you before you go. Your birthday is May the 4th.
That's right.
So which is the best Star Wars movie?
Ooh, which is the best Star Wars movie? I would probably have to go with the first one, the one that started it all. The themes were the closest to a lot of great classics of literature, and they weren't the effects were still really good and strong for the time. But there wasn't any part of it that was, kind of Jar Jar Binks trying to,
that's true.
Trying to sell toys and everything like that. But the first one, if I remember correctly, came out in '77, before I was born, and I think Empire Strikes Back was '80, which was the year before I was born, and then Return of the Jedi was '83. And my late mother looked a lot like Princess Leia.
Yeah.
And so like some of the later ones, it was cool to it kind of look like my
cool.
mom was.
A little
That's
uncanny.
awesome.
But yeah, it's hard to beat the first one.
Yeah.
That is a beautiful,
it's a classic for a reason.
originalist answer
there you
to
go.
the Star Wars question.
Well, thank you again, Justice Sullivan, for joining us. This has been an absolute delight, and we are absolutely honored to have you here today.
Thank you so much for having me, and I appreciate everybody being curious about the work of our court and our branch, and invite everybody to come see us sometime.
Absolutely, and I'm sure we will be in your courtroom before too long. So, and for the rest of our listeners of Rightly Decided, if you have enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.